could have waited for some time. Anyways. Yes, we are ready.
For judgment, item number 1.
Now, in this case, RFA, this court finds that the issue whether the private company who constructed the railway lines are necessary party or not has not been framed or considered. In view of the above, this court found it fit to remand the matter back to the learned trial court under Order 41, Rule 25, by framing the issue whether the private company is a necessary party, and thereafter the learned trial court will take additional evidence on that issue and decide the issue within 1 month from the date of this order. Thereafter, the parties are to appear before this court again with the issue decided. So both the parties are to appear before the learned trial court on 10/6/2025. On 10/6 for necessary orders, and then the matter will be listed again after 1 month. This matter is released from CAB. Yes.
Obligation.
My Lord, I am standing on behalf of my senior counsel, Abdul Engliana. My Lord, with respect, in respect of Part 2, item number 5, can this matter be taken up after 3 weeks?
Item number 5, RFA. Has the consent of the other side been taken?
Yes, my Lordship.
You have taken?
Yes, my Lord.
Okay. Mention is made on behalf of Mr. F. Lalengliana, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, list, when you want it, after 2 weeks?
3 weeks.
After, have you taken the consent
Yes,
for 3
ma'am.
weeks?
Yes,
List
Your Lordship.
after 3 weeks. Yes.
Basic Lordship indulgence. In mentioning Part 2, item number 7, my Lord, if this matter may kindly be taken up on Thursday.
Okay. Parties,
Yes,
both the parties are
My Lord.
present? Yes, during this week, Thursday.
For admission, item number 2.
Yes. What is the stage?
The newly implemented respondents, I believe that Miss Mary is going to represent them.
If she's not present, awaiting appearance of the newly implemented respondents. That was the last order.
Miss Mary is here. She's coming.
So what is the matter about?
It's
the
regarding
company?
regularization of the SSA employees, my lord.
Okay.
And this
So-
is the judgment dated 17/3/2023.
Oh.
But till date, no steps have been taken as dated by this court, my lord.
Steps
course.
have been taken?
No steps have been taken. They are taking together the whole CSS employees by the state respondents. Well, the present petitioners were under the judgment order dated 17/3/2023, wherein specific direction was made to consider the case for regularization within a period of 6 months.
So now,
The last,
recently,
the latest
yes,
development,
7 to 11 are pleaded.
yes, my lord, that is
Now, in
correct.
the last court date, 7 to 11 were not represented. Yes, Miss Mary, are you going to represent the
Yes,
newly
Your
implemented
Lordship.
7 to 11?
I'll be filing my power today, Your Lordship.
Mr. Victor L. Ralte, learned counsel for the petitioner is present along with Mrs. Mary L. Kiante, learned counsel, who submits that she will be representing the newly impleted respondents number 7 to 11 and will be filing her power within the course of the day. In view of the above, list the matter after 2 weeks.
1 week, my lord.
Make it 2 weeks for the newly impleted respondents to file their show clause reply. Yes.
Item 3.
My lord, I am led by my senior Mr. Lal Pakoma, who is on leave. Yes, and my lord, if this matter may kindly be passed over as a last item.
Where is he, Mr. Lal
He's
Pakoma?
on legs. He's on legs in the.
So
other
can we make it a time being matter?
Up, maybe after last time. Yes, after taking.
Time being
as a last
matter.
item. My lord, my lord. Right.
Item 4.
Yes, Your Lordship. Notice has been sent to the respondent number 2 and is still awaited. Notice
date
was
of
sent
filing,
on
is it?
17 March.
We can appoint an amicus in the meantime.
Yes,
Isn't
Your
it?
Lordship.
For this one. Ms. Vanessa, learned additional PP for the state respondent is present and submits that return of issuance of notice upon respondent number 2 is still awaited. Stop. It is seen that this is a jail appeal against the impugned judgment and order passed by the
Fast track court.
fast track
I-zone.
special court within brackets POCSO Act, close bracket, comma, IZON, dated 25/04/2023, wherein the appellant was convicted under Section 6 of the POCSO Act and sentenced to suffer RI for 10 years and pay a fine of rupees 3,000. Is there a default clause? Well, this was not mentioned in the last order, that's why. With a default clause. It is seen that the appeal was admitted.
Yes, Your Lordship. In default,
By-
another 3 months.
I've mentioned default clause. It is seen that the appeal was admitted by this court's order dated 12/03/2025. We may await for return of service of notice upon the respondent number 2. Meanwhile, this court find it fit to appoint an amicus curiae to represent the appellant, registry to do the needful. LCR is allowed. The registrar is also to call for the TCR list after 3 weeks.
Obliged.
Item 5.
Yes.
Lordship, notice upon the sole respondent was already completed, And in the last court order, Lordship, order dated 14/5/2025, this honorable court observed that if the respondent is not represented and amicus curiae may be appointed in Lordship.
But how have you issued notice to the respondent?
Lordship, that we have filed affidavit in respect of personal service upon the sole respondents.
What does the affidavit say? To
affidavit-
dusty mode.
Yes, it does, Timothy, Lordship. We
Let's
take Lordship to the last order, 28/4/2025. Your Lordship had passed an order, 28/4/2025. It is seen that notice upon the sole respondent is completed.
Okay, but let's see the affidavit anyway.
Lordship, yes. We have filed on
Yes,
4th
okay.
April 2025, Lordship. At his
Viresh
residence.
Das, is it?
Yes, yes.
So where is he, this person, Viresh Das?
He's from Arlal Oya building, Tuipot, Klang, Lordship. He's staying with his family.
Very strange. Then why is he not coming?
Yes, yes.
Maybe if we appoint a legal aid, the legal aid can take the, council can take the trouble
Possibly,
to
yes.
contact the,
Very true, Lordship.
yes. Mr. Johnny L. Tauchung, learned counsel for the appellant is present, while none appeared for the sole respondent. Good stuff. In view of this court's order dated 14/05/2025, this court find it fit to appoint an amicus curiae, to appoint a legal aid counsel
Correct answer.
to represent the sole respondent. Accordingly, where's the list? There used to be a list of legal aid counsels. Oh, here it is. Accordingly, any legal aid counsel present today? Accordingly, this court find it fit to appoint Mr. Jordan Rohingya as the legal aid counsel to represent the sole respondent. The registry to inform the learned legal aid counsel, and copies of the appeal petition is also to be duly furnished to the legal aid counsel.
Yes.
Has LCR arrived?
No, Your Lordship, it's not right. If I'm not wrong.
Registry is also to call for the TCR list after 3 weeks.
Item 6.
Yes,
May I please, Lordship? Lordship, this matter may be kindly fixed on tomorrow for hearing.
you
Tuesday.
have filed a written objection?
Yes, my lord.
Okay. Mr. Johnny L. Tochong, learned counsel for the applicant/appellant is present along with Mr.
Arlel Woodfield.
R. So-and-so, learned counsel for the opposite party.
Present.
Number
4 and 5, my lord.
4 and 5,
My Lord, I'm
along with
appearing on behalf
Miss
of Balsamwani, respondent 1 and 2.
Balwant Samwani, representing respondent number 1 and 2. On the submission made by the learned counsels for the respondents, list the matter on tomorrow's date. Okay. Yes.
Item 7.
Yes.
Lordship, last court order, we are waiting for the return of the service from the respondents, Lordship.
Who are the respondents?
Respondents are from Zog Kothari, Lordship. If the notice is not completed, then I may be allowed to do a DAS service, Lordship. Since
When
we have
was
filed,
notice served?
notice was
When
served,
was notice issued?
Lordship, maybe sometime in the month of January 2025. So it's a long time.
Heard Mr. Johnny L. Tochong, learned counsel for the applicant/appellant, who submits that since there is no return of service of notice upon the respondents, he may be allowed to serve notice upon the respondents through dusty mode. It is seen that notice was issued to the respondents in the month of January, is it 2025?
Lordship, yes.
However, since there is no return of this notice issued to the respondents, this court find it fit to allow the learned counsel for the applicant/appellant to serve notice upon the respondents through dusty mode. Accordingly, necessary steps is to be taken by the learned counsel for the applicant/appellant, and affidavit is to be filed to that effect, lest after 3 weeks.
Lordship, yes.
Item 8.
Lordship, there is a here there is a delay of 133 days, Lordship, for filing this connected appeal, Lordship.
Yes, are you going to file a written objection?
No, my lord, we will
Okay.
not be having any objection.
We heard Mr. Johnny L. Tauchung, learned counsel for the applicant, who has filed the application for the condonation of delay of 133 days in filing the connected criminal appeal against the judgment and order dated 18/10/2024, passed by the Special Court, NDNPS Act, Champai, in criminal complaint number 197/2023. The learned counsel for the applicant submits that the reason for the delay of 133 days
Lordship,
is explained in
yes,
paras.
paragraph 2, A2,
Okay.
M2, A2,
Okay, para 2 within brackets small a 2,
M,
para 2 within small brackets m, which is
Lordship, which is no intentional or willful negligence part of
in
the
a few lines. Just what is a to m?
is regarding the delay, Lordship. Because
so-
there is no inadvertence or there is no willful negligence on the part of the applicant. The reason is due to, Lordship, since the applicant was in jail and he had approached the council belatedly, Lordship.
Okay, so the appeal is for setting aside the conviction.
Lordship, yes,
Okay.
yes.
Submits, which is due to the fact that the appellant, after being sent to jail on his conviction, had taken time to get the copy of the judgment and order, and also to approach a counsel from the jail. Full stop. And then Mrs. Vani Siame, learned additional PP, submits that they will not raise any objection to the prayer for condonation of the delay of 133 days. Full stop. Having heard and considered the submissions made by the learned counsels for both the parties, this court has perused the reasons for the delay, which is highlighted in para 2 within brackets A 2, para 2 within brackets small n. This court, on perusal of the reasons given for the delay of 133 days, is satisfied that the delay is not due to any laches or negligence on the part of the applicant/appellant, and accordingly condone the delay of 133 days in filing the connected appeal against the judgment and order. Copy paste. Yeah. Yes. IA number 17 of 2025 thus stands allowed and disposed of. Now, in the main criminal appeal on the disposal of IA 17 of 2025, heard Mr. Johnny L. Tolson, learned counsel for the appellant, who submits that there are sufficient grounds for setting aside the judgment and order dated 18/10/2024 passed by the special judge in the NPS Act, Champai Judicial District in criminal trial number 197/2023 in Kozol PS case number 19/2023, wherein the appellant was convicted under section 21 within bracket C of the NDNPS Act and sentenced to undergo rigorous imprisonment for 10 years and pay a fine of rupees 1 lakh in default SI for 6 months. Full stop. The learned counsel submits that what?
Lordship, there is a clear violation of the mandatory provision under section 104 of the CRPC.
Okay, submits that there are violations of the mandatory provisions under the CRPC and the NDNPS
Yes,
Act,
Lordship.
for which the impugned judgment is liable to be set aside. Appeal is admitted. Issue notice to the respondents. Then Ms. Bani Siami, learned additional PP, accepts notice on behalf of the state respondents. Then TCR to be called for. List after 3 weeks.
Item 9.
May it please your lordship. My lord, this IA is regarding a prayer for condoning a period of 653 days in filing the connected RFA.
653 days.
653
That
days, my
is
lord.
1 year, almost 2 years.
Yes, my lord. Correct. There are two main reasons for the delay. The first is that the applicant was not aware of the impugned judgment order because he was not informed by his previous counsel. And the second reason is that because of the delay, because of the time we took for applying for certified true copies of the folio.
How long did you take to apply for certified true copy? When did you apply for certified true copy?
My lord, we have applied it for numerous times because initially it was not given to us in a folio version. So the first time we,
So it was given to you after how many months after you applied for certified true copy? Usually they give it within 2-3
My lord.
days.
my lord,
Anyway, we'll issue notice. Let's
yes,
see.
my lord.
Right, Mr.
Eldrin Zoltan Moya.
Idrin Zoltan Moya, learned counsel for the applicant/appellant, who has filed the instant application under Section 5 of the Limitation Act, 1963, read with Order 41, Rule 3, capital A of the Code of Civil Procedure for condonation of a delay of 653 days in filing an appeal against the judgment and order dated 16/05/2023 passed by the learned court of Senior Civil Judge -1, Aizawl, Mizoram in money suit number 166 of 2013. Issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Deeply obliged.
Item 10.
Please, Your Lordship. My Lord,
Yes.
this IA is for condemnation of the delay of 153 days, my Lord. Filing the connected MAC appeal, my lord.
Hmm.
153 days, my lord.
Okay, we'll issue notice first. Now, previously, for some time, you were the government advocate, isn't it?
My lord.
So this thing resigned from the post or what?
Recently, my lord.
Okay. Third,
And this
Mr.
is a MAC appeal, my lord. Actually, this is a MAC appeal for
So
the...
you're still the government advocate?
No, my lord, this is for the New India insurance company.
No. Mac appeal, it's a different matter. I'm
no.
just asking in general. Are you still the government
No, ma'am.
advocate? No longer. Okay. Anyway, third, Mr. Benjamin Lalfamwana, learned counsel for the applicant slash appellant who has filed the instant application under Section 5 of the Limitation Act, 1963 for condoning the delay of 153 days in filing an appeal against the judgment and order dated 27/09/2024 passed by the Learned Motor Accidents Claim Tribunal, Aizawl, Mizoram, in MAC case number 3/2023. Full stop. Then you can issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Obliged, ma'am.
Item 3.
No, time being matter. This is a review petition.
I apologize, Lordship. I was on
That's
executive
okay.
order number 1.
Yes.
My lord, by this filing this review petition, we are basically praying for a review of the judgment and order dated 29/11/2023 passed by this honorable court in RFA 29 of 2023. Now, the facts leading up to the case, Your Lordship, is that I am the owner of one LSC number 954 of 89, located at Zemabok, Mid Lamwal, and whereas the respondent number 1 is the owner of 2 LSCs. Now, what happened was that the respondent number 1 had erected one pole, where claiming to be the owner of the area which I believe is within my property, and he displayed his LSC. Now, being aggrieved with that, I filed a complaint before the Revenue Department for spot verification. Now, instead of conducting spot verification, the respondent number 3, that is the director, issued a notice inviting the parties for a meeting. Now, in the meeting, I was personally present, whereas the respondent number 1 was had sent his representative. Now, during the meeting, the representative of the respondent number 1 could not point out the actual location of the property of the R1 in the map. However, despite this fact, respondent number 3 issued a settlement order dated 17/1/2022, wherein it was held that the petitioner land overlapped the land of the respondent, and the petitioner's land was reduced from 2,711 square meter to 995 square meter. So basically, being aggrieved, I had approached the court of the civil judge challenging the settlement order number 1, as the same is not based on spot verification number 1. Number 2, to declare that I am the owner of my LSC as per the boundary description, and to cancel the LSC of the respondent up to the extent that it overlaps my land. So that is basically the crux of the case. Now, provide order dated 19/6/2023, passing the civil suit, which can be found at page 71 of my review petition. Page 71, Your Lordship. Annexure 11. Your Lordship has that? If Your Lordship can kindly turn to page 75, that is the relevant paragraph.
Yes.
Your Lordship, may I read? After thoughtful consideration of the reliefs claimed on considering Section 9 of CPC 1908, Order 14, Rule 2, Section 76, 89, 90, and 96 of the Mizoram Land Revenue Act 2013, it is considered that as being aggrieved with the settlement order dated 17/1/2022 passed by the Revenue Court, the plaintiff herein would have to approach the proper forum as provided under Section 89(3) of the Mizoram Land Revenue Act 2013. For the reasons stated above, the instant suit stands rejected under Order 7, Rule 11D of CPC as barred by law. So being aggrieved, Your Lordship, I had approached this Honorable Court and filed the RFA. Now, one of my grounds was that the civil court is not barred from entertaining the civil suit, in as much as there is no such bar. And during the proceedings, Your Lordship, in fact, by order dated 10/8/2023 passed in the RFA, this court on that issue, on the point of whether a civil court has jurisdiction to entertain suits or not regarding title and possession, this court had directed the government to submit a clarification. That clarification can be found at page 96, annexure 15 of my review petition. Page 96, annexure 15.
96. Yes.
May I read, Your Lordship? Referring to the order dated 10/8/2023 in RFA numbers 29 of 23, I am to submit clarification of the query made in the said order as under. With regard to the revenue officers to act as revenue court in terms of Section 77 of the Mizoram Land Revenue Act 2013, the appointment letter of any revenue officer is to be regarded as an authorization letter from the state government for such revenue officer to act as revenue court, and no other authorization letter order is required for this purpose. The reason for this clarification, Your Lordship, is that one of our grounds was that as per Section 78, a revenue officer has to be authorized specifically to act as a revenue court, but that has been clarified. The second portion is regarding the jurisdiction. As per Section 106 of the Mizoram Land Revenue Act 2013, the civil court is only barred to set aside or modify any order made in respect of land revenue assessment, collection of land revenue or taxes, or imposition of penalty on area. As such, there is no bar for civil court to make decision in dispute regarding boundary possession and ownership of property. So this is one of our main grounds for this present review petition, in as much as we believe that there is error apparent on the face of it in light of the clarification given by the concerned authority. Now, coming to the Act itself, Your Lordship, the 2013 Revenue Act, Mizoram Land Revenue Act of 2013, I would like to point out certain provisions.
Yes.
The Section 96.
Section 96, okay.
Save as, Your Lordship has it, I apologize.
Yes, please read.
Exclusive jurisdiction of revenue courts and bar of jurisdiction of civil courts. Save as otherwise provided in this Act or any other law for the time being in force, a revenue court shall have jurisdiction to determine, decide, or dispose of any matter which it is, by or under this Act, empowered to determine, decide, or dispose of, and no civil court shall exercise jurisdiction as to any of such matter. Subject to the exception herein specified, no civil court shall exercise jurisdiction as to any of the following matters, namely, claim against the government relating to any property. The present case is regarding two private persons. Objections to the amount or incidence of any assessment, collection of land revenue under this Act. So that is not covered by us. Sorry, it's not relevant for us. Claims connected with or arising out of any proceedings for the realization of land revenue or other demands, recoverable as arrears of land revenue under this Act or any other law for the time being in force. claims to set aside on account of irregularity, mistake, or any other ground, except fraud, sales for arrears of land revenue. Claim against the government. I've skipped this portion, Your Worship. Distribution of land or allotment of land, revenue or partition of any land under this act or any other law for the time being in force, and claim against the government. Now, this F is slightly tricky in a sense that,
And so under F, distribution.
correct. So regarding that, my lord, in my humble opinion, it says distribution of land or allotment of land. This, in my humble interpretation, would relate to fresh lands being allotted by the government.
Okay, then revenue or partition, what is this?
Revenue or partition of any land under this act or any other law for the
Partition
time.
of any land under this
Partition of any
act.
land. But this cannot be read in isolation again.
Okay, it has to be read with
The other sections as well,
Okay, which
particularly
sections?
106.
106. I think this is the main this thing, isn't it?
Yes, Your Worship.
The jurisdiction of the revenue court.
Bar of civil
You have to say that the jurisdiction of the revenue court
Is
is
limited
only
to-
with this,
Yes, it's limited to collection of taxes.
only limited to this.
Yes.
And then in your case, it is not limited to this, it's beyond what is the, mentioned in the
Correct.
jurisdiction, isn't it? So,
Correct.
okay, so section 106, what does that say?
It basically says, no suit shall be brought in any civil court to set aside or modify any order made in respect of land revenue assessment, collection of land revenue or taxes, or imposition of penalty on arrear. So basically, the bar to the civil court is in respect of collection of taxes and other revenues that may be payable. Nothing to do with title.
But this is in appeal, whether the appellate court, we have to look at the power of the appellate court, I said.
I believe that it will include this revenue court as well.
Okay.
In any event,
So
Your Worship,
106, then where's the provision for the appeal? If I'm not mistaken, the judgment had said that since there's the provision for an appeal, it should go on appeal to the other court, isn't it? To the appellate court.
appeal should be only in respect of those subject matters which has been pointed out and clarified by the Revenue Department.
Okay, that
Not
is
in-
96.
Yes, not in relation to title or property or possession.
Okay, so you're saying your case is title
Yes,
and it's
possession.
regarding title and possession of a certain plot of land, which is
Because-
not covered under 96.
Correct.
96.
Also,
Okay.
Your Lordship, if we can kindly have a look at this section 97 as well.
Okay, 97. Yes.
This is power of the civil courts. It says nothing in section 93. This should be read as 96. I have clarified this by way of RTI. I have annexed that in my review petition as well. This 93 should be read as 96.
Okay. So nothing in section, let's see what is 93 anyways.
It relates to review and modification.
So now then we have to be clear, because I think at the time of considering this matter, section 97, where the section 93 is mentioned, was read as section 93.
Most probably. Most probably.
It was.
So, if your lordship can kindly turn to page.
So this is supposed to be 96, you're saying,
Yes.
this 93.
If your lordship can turn to page 93 of my review, that is the copy of my RTI application seeking clarification.
Page?
This is
Page what of your
page 93 of my review,
93? Okay.
annexure
Yes.
13. Your lordship has that serial number 6. The second question, your lordship, kindly clarify whether the words section 93 appearing at section 97 of the Mizoram Land Revenue Act 2013 is a typographical error, mistake, due to the fact that 93 relates to rectification of mistake by review. If yes, whether section 93 appearing at section 97 should be read as section 96 instead. The reply is at page 95, annexure 14.
Yes.
A very short answer, it says correct.
Huh?
It's a very short answer, they basically
What
said
did they say?
correct. They said it's correct.
Which is correct. Therefore, no copy. Two correct. What is two correct?
That's the
Kindly
second question.
clarify whether the words 96 appearing is a 97. So, what does correct means? That 93 is correct or it's 96?
But if we look at section 93 verses 96 and 97, in my humble opinion, it should be read as 96 because 93 would make no sense.
You see, if this is clear, but it's still not clear.
Be that as it may, Your Lordship. Be that as it may. If you, with Your Lordship's permission, I'll just read out 97. Nothing in this section 93 shall be, nothing in section 93 shall be held to prevent the civil courts from entertaining any of the following suits. B, Your Lordship. Suits between private parties for the purpose of establishing any private right in case it is affected by any entry in any land record, or suits between private parties for possession of any land in a whole survey number or subdivision of a survey number or part thereof. So this
That
is
is there, but it says nothing in section. So 97 has to be read with 93. That's the whole problem, isn't it?
Right.
This is concerning rectification or mistake by review. It's only in the case of rectification of mistake by review that 97 is to be applied. While you had approached the court in an appeal.
otherwise, Your Lordship, since we have a dilemma on that point, on this 97, may I make one small humble request, Your Lordship? If the government council can
Yes,
clarify
can
this,
clarify this. Where's
this
the government
point,
council?
I think that should solve all the confusion.
She sound like, but she just appeared and kept his.
Because I remember while considering the RFA also, this issue had come up and we had looked at 93 also, where it says it's only for mistake by review or mistake by review that this 97 will be applicable. So unless we are clear on this, we
May not
cannot
be
see
able to
whether,
proceed, yes.
isn't it? Where's she?
Lots. Fisher. Lordship, if I may, I'd like to make some few points with regard to the main issue today.
No, but I think he has a valid point here because I remember if it is 96, if 97 in section 97, this 93 is to be read at 96, the whole concept will this thing change because then the civil courts is not prevented from dealing with these issues A, B, C, B. Okay.
Because
But
as,
if it is 93, then 97, we cannot take 97.
as on date, Your Lordship, this basically amounts to tying up the hands of the civil court on all property issues.
But then if 93,
I think she can clarify.
so this clarification has to be
Lordship, in
required.
my humble opinion, as of now, this act was enacted in the year 2013. Means more than 10 years past. And rightly or wrongly, it is like this present she contains, Lordship. That's
Okay,
why,
are there any judgments of the coordinate bench of this court on this matter? Nothing yet.
Lordship,
Regarding an appeal
yes.
from concerning the jurisdiction of the civil courts.
Thandabala case, yes.
So produce some judgments of the coordinate bench at least, so that we'll see. Because now the council is saying this under section 97, this section 93 should be read with 96. And they had filed an RTI application. Now the RTI application reply is very vague. Yes. What does yes mean? Yes means it should be read as 96 or it should be read as 93. It's not clear.
But Your Lordship, this matter pertains to the legislature, so not the executive. So, as
So
of
the
now-
government advocate can find out.
and apart from that, Your Lordship,
Because he's representing the review department anyways who made the legislature, isn't it? Yes.
apart from that, Your Lordship, this case is review matters, not an appeal.
No, it's
So
not
I'm
an
afraid
appeal.
of that. We are traveling beyond the scope of review, Lordship. And then-
Exactly because it is a review matter, there could have been a mistake in the interpretation of section 97, where 93 should be actually read with 96.
But in my humble opinion, Lordship,
Uh,
as of date, if there's a legislative amendment to the to support of his argument, then maybe a valid reason, Lordship. But as of now, there's still no amendment. So we can just rely upon the present
So let's
enactment,
let's
Lordship.
clarify, because RTI application answer is very correct. What does correct mean? They had asked, the question that was asked was, because maybe this issue had not really cropped up, there's no judgment of the coordinate bench also on this regard. So the question that was asked was to clarify whether the words section 93 appearing in section 97 is a typographical mistake and it should be read as section 96 instead. That was the question. Now the answer is correct. What does correct mean? At least let them clarify this, the government advocate. They will fix another date for hearing on this. Yes, government advocate, where were you? Okay, you received a copy of the review application, isn't it? With all the documents. Now, at page 93, there's an RTI application. Okay. Now, can you clarify in serial number 6, the second question, okay, whether in section 97, instead of section 93, it should be mentioned section 96 or not? That was the question, whether there was a typographical mistake. Okay. Now, the reply is simply correct. Now, we don't know whether this correct means that in section 97, okay, it mentions section 93. So the question is whether it should be 93 or 96. It says correct. So correct means it is 93 or it should be 96. Get this clarification?
Yes, my lord, I'll do that.
Are you getting my point?
Yes, my lord.
Look at section, have a look at section 97 of the Mizoram Land Revenue Act. Just give her the copy. Now, in section 97, it mentions that it should be for review. Okay, what's 97? The exact words. Anyways, it mentions that nothing in section 93 shall prevent the civil courts from entertaining any of the following suits. Now, 93 here refers to rectification of mistake by review. Instead of rectification by mistake from review, the council says that it should be 96. That is the par of the revenue courts. If it is 96, if in 97 it becomes 96, then the civil courts can decide suits between private parties. Okay, and it says that the civil suit under which was appealed against is a suit under private parties. Are you getting my point?
Yes,
So get the clarification whether this section 93 mentioned in section 97 should be read as section 96. Because frankly, it doesn't make much of a sense if it's 93. It's difficult to understand. Because the meaning then becomes different. So you get that clarification. If you want it in writing, you can file it in writing, the clarification and written this thing, the RTI, or if verbally also this clarification.
I will get it in writing.
Okay. Some commitment from the revenue department, isn't it? but of course this will be important. And frankly speaking, 93, I think 93, it's a little bit difficult to understand what the act is trying to say. Okay. Anyway, I heard Mr. Lalfa Pama, learned counsel for the review petitioner, along with Mr. T. Leonard Siama, learned counsel for the private respondents, and Mrs. Caroline K. Lalmoipoi, learned government advocate for the state respondents. On hearing the submissions made by the learned counsels for the parties,